and obtain help from the other side. The LCR delay applicant is keeping well, they are paying for the customer repayment. Every time we take it up from other different. The other side is
Okay, when? Huh? When? Motion. The matter stands adjourned on the prayer of the learned counsel for the petitioner with a consent from the respondent. List it on 5th of October.
okay.
Yes. When? Go to the senior bench. Okay, same order. I got to adjourn. When?
27th of September.
No, not adjournment. Will go to October. Yes. When? Huh? 27th of September. In interim order. Oh, Pony. That half you have given. Okay. So I now know that you don't have any further interest on the paneer. Okay. No sort date. You can have both the cake and rest I will not say. Yes. On the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed in 25th of September. Go to the senior bench. Bail of which offense? Yes.
Motion BA item number 1.
Whatever item 3, 4, and 6. 6 and some I think there must be some bail hearing. 30 and 53 bail hearing. We'll take together along with the bail. Along with item number 30. 3, 4, and 6 will take along with item number 30. Okay. One. Okay. Yes. It seems it's drowning. How many days? Huh?
1 month, 2 days.
Have a short date. This not seems that it's a case of murder. 8th of September. City.
Number 2.
Yes. Let him go. Huh? What have you stolen? But what is the allegation? What about 18-8? I think he should go. To the satisfaction of that, you at least be ready with that. To the CGM satisfaction of Kamrup Metro 25,000. Yes, next. No. Okay. 3, 4, and 6. Not now.
Item 5.
And then certain application, my CD, my over the station. Same computer, my laptop.
Here also, my mark is to the satisfaction of
My laptop. CJ photo.
CGM professor. 25, 50,000. Yes, next.
7.
What about city with injury report?
Yeah.
When? 11th of September.
8.
What about that matter? Kidnapping and ransom when? 12th of September. Huh? 13th of September. CD.
9.
Yes. Yes. CD. It's Colton Bazaar. That he was taken to somewhere. He tried to fly away and attack the unarmed constable. When? 12 night.
Another case is 6.8. Another case is 6.8.
Panbajar is different, not linked to this. Then
10.
yes. CD. Or
This 14 is self
yes. One CD. 14.
11.
CD. No. So, how many days? Huh? But that was something different. Who was he? How he was a driver? He came to the owner and said that this was the thing. You are the main person who blocked the vehicle. Why should you drive?
From my position, I have enough to all the materials, all the civil, everything is visible from other person. From my, our position, nothing is visible.
So what is your name?
My name is.
Where is the affair?
Number 10.
Your name is Dilbar.
I have another civil, all the civil medal, the number 14 onward. Number 16.
Where is the forwarding, Swas?
Forwarding it to face value. Is the and my forwarding at is 20.
Okay, other has we have granted, let him go. Otherwise, all recovered. all everything is recovered, not from, but nothing is. My apprehension was that he was the person who blocked the vehicle, and the main person. Three parts in this incident. One is the robbery, other part is selling it to somebody else, and somebody received the stolen property. So we have granted bail to them. Now it seems that nothing has been recovered. So our doubt was that he is the person who robbed.
Also, for previous include the driver.
And driver came. When can you have this case there?
Maybe available in the office. That's not good.
See,
It-
he is having information, maybe available in office on it.
And not available.
He will not be. He will be. Yes.
Motion AB item 12.
That is our apprehension. That's why we call the CD. Yes. Yes. We'll call for the case there.
Because I've given at that particular point of time, I was not present here. It means movie tickets and all have been managed here.
Otherwise, there is specifically this is person.
Specifically name. Specifically name.
He comes and something is there, let me appear and make my skin clear. Only my humble prayer is here for an immediate clear.
It is short, maybe 6 minutes.
Otherwise, it will not be, initiation not go.
See, to CD. When given early date.
On 39.
13.
13.
Much obliged.
Only anxiety is that love relation, these are, we don't have any problem, but we have we are not inclined to grant interim because of the reason that you have pretended that you will, allegation is that you will disclose the private photos. That's why that is there. Come to the effort.
Other offenses are available. 490.
It's difficult. Not only that, threatening to kill my family. Forget about that. That maybe we will not believe it. And to make my photos viral. That is why we are not granting CD. Otherwise, CD, give a date.
493 is not that.
We'll see. Bail. 12 men.
14.
Frustrated. Now what to do? Face. Who is Sahil? Is the husband? You are the brother. Okay. Let him go. Other persons give same as 35. Allow. Yes, 35. Similar order.
15.
Injury, land dispute is fine, but can land dispute lead to injury landing in hospital? You will have to see it. We understand, but will that will suppose somebody has wrongly mutated their name in your property? Will that permit you to beat them so badly that they are in hospital? We'll see, because specific allegation is that so and so is under hospital in a critical condition. We'll have to see whether he is in critical condition. Appearance, 19 CD.
16.
$307. No ingredients.
dispute regarding job card management. We are the job card holder.
Hmm.
Then that president has been missed a huge amount. They are not paying. Information is the father of that president. On 24, we lost complaint before the SP because OC did not receive our affair. Then SP,
Where is your affair?
my affair, they are the way of check because the affair, it is paid 37 lakhs. 24, we lost complaint with that.
According to the FIR, we need this kind of president, so non-corrupt. He is doing everything for the society, and for people like you are obstructing him. CD interim. Record your statement. 11:10. But you should not disturb this so good a president. He is going from village to village, looking at how houses are built, and you, without any reason, you are beating him up.
No, nothing.
Okay.
17.
Husband 302 is there. Maybe 306. May not be 302. But what is the period of marriage? 2 years, not even 8 months. 8 months. Specific allegation of torture is there. Even if it is suicide, it will come under 306. CD. 14:9.
18.
Yes. Hmm. CD. Pathetic. Don't ask any further. We'll reject right now.
19.
Can people go to that extent? Let there be a interim here. CD interim. Get statement. Where is the girl? Mother. 13th of October. See, interim.
20.
Considering the nature of allegation and the age of the victim. No? Yes. Will that permit burning of a house of a lady? We'll see it whether it's burning or not. No. No. When there may be land dispute, will even cause in case of a land dispute, but this is not permissible. A helpless lady allegation is there. It's not a case for interim. We'll see. Huh? That is up to Mr. Bhatta. Yes. 14:9.
I think 21 for motion.
And I see that the petitioner has alleged the order of naming the search that was framed under Section 276, 417 and 420. The case of the petitioner is that over the affair as well as the 160 statement, no case of 376 has been made out. And at the time of naming the search, the learned from
Okay, 376 not made out. Others?
others also.
Huh?
Others also. There is no any purpose of the city about it. At the time of naming search, the learned person played the all materials before the learned court below.
Hmm.
But considering these materials, by how much suggestion and further proceeding may be stayed. This is my humble suggestion at this stage.
Why should we stay the further proceedings? Satisfy us.
President, first of the one,
Notice to
We'll issue notice and call for the scan copies.
and my office officer, because the case is at a state of evidence. If the evidence is going on, then this matter will not remain. The so-called 164 statement here, the.
Will not stay the further proceeding.
My office officer is the.
Because even if not 376, the cases under cheating is absolutely made out. And then also in view of some judgment, even 376, you introduce yourself as something, you said that I will do this, you went to the court, pretended to marry her by notary, then kept her somewhere. What are all these? Suddenly will withdraw.
What are the cases that she has already admitted that she was married by using the notary. So far, the mention that the section 90 is concerned that the consent taken from the victim.
Two options for you. Either a notice and calling the scan copies of the case diary. This is first option. Second option is you argue, we'll decide it right now. Either dismissing,
What is my view?
yes, notice, decision application and the notice and scan copies of the case diary as well as the record case diary of
Yes.
police case number.
Yes.
Case diary
348, 2019.
Patasarkusi police PS case number 348 2019 and the record scan copies of record of PRC or RC whatever you say case number. At least you must be ready with that. No, we do not require any lawyer's help. From tomorrow we will not even hear you. Yes, sir. Huh? Returnable after 6 weeks.
I think 22.
Yes.
I have been convicted
Mm.
after two sessions, 448 for 3 months.
Period. Tell us the period.
324
Mm.
for 1.5 years. And there is some final.
In criminal revision, notice returnable after 6 weeks, notice within 5 days, whatever accepts, no formal notice. Okay. I had liখিব, same, not notice na lage. With the connected revision, or generally we have passed this. Connection revision petition notice has already been issued. Stop the determination of the criminal revision petition. The petitioner shall be allowed to remain all previous bail. I stands disposed of.
23.
What is the
For example, what is the next date? 5/9. What do you say? Assist us what to do.
It will go by the decision of the my lord,
Hmm.
then I do not have it.
Yes, but that is binding upon us.
But only thing is that for the purpose, for what purpose it was sent to the mail of the trees and the fence.
Hmm.
That point was not discussed.
In the
Because whether it infringes the fundamental rights, so.
where is that important paragraphs of 3 judges bench?
Basically, there are 26 and.
You say there are some stay of the in some other cases
That is not a.
relating to this case.
Same matter, for simple case.
Hmm.
Only thing matter, other way around.
Okay.
Here matter, our petition was allowed.
Uh,
In that case, matter, their petition was matter, that voice sample need not be made. But it is a case of voice.
For example, your petition was allowed, then the other CBI came before this court and there was a stay. So meaning thereby, for example, can be taken, no, there was a
It
direct,
cannot be taken.
now cannot be taken. What is the stage of this trial? Investigation says. Who is appearing for here CBI? Okay, Bhattacharya, we are issuing a notice, and for the time being, you may proceed with the investigation, but voice sample is dead. We'll examine it immediately after. You also get to come prepared. Okay. Somehow I missed this. I was supposed to come prepared, but not ready as to that extent. So that's why we'll examine immediately. Heard Mr. BM Chaudhary, Learned Counsel, for the application. This is an application under section 482 of the Code of Criminal Procedure. Full stop. By the present application, an order dated. What is the order? Order dated. Order dated 8/3/2022, passed by the Learned Special Judge Assam Guwahati, allowing the prayer of the investigating officer for recording voice sample of the petitioner in voice sample of the petitioners in connection with SCB PS case number 9/2016, and directing the petitioners to appear before the investigating authority for recording such voice sample is under challenge. Full stop. Mr. Chaudhary submits that while passing the aforesaid order has been passed very mechanically without considering the right of the petitioner protected under the Constitution of India, inasmuch as though such voice sample can be directed to be collected in terms of the decision of the Honorable Apex Court. In the Honorable Apex Court, in the case of Ritesh Sinha versus State of Uttar Pradesh and others, reported in 2019 8 SCC phase 1. However, the parameters required for such determination has not been considered while passing the impugn order by the learned court below. Full stop. This matter needs further consideration. Accordingly, issue notice returnable on. What I could give a date? Returnable on. 19/9/20. Okay, you give a date. Maybe 21/9/2023. Considering the matter in entirety and the arguments advanced by Mr. BM Chaudhary, it is provided that the impugn order dated 8/3/2023 shall remain suspended till the returnable date. However, it is made clear that there shall be no bar for the SCB to proceed with the investigation. Except the collection of voice sample in terms of the order dated 8/3/2022. Yes, silent order.
Item 52 of supplementary list.
Yes.
CD was called for actually.
Motion. Motor, this is a serious case. We want to see that. We do not, because yesterday matter was listed, I said we'll take it to call for the case diary. Then the prayer was made that case diary will be produced today. Here, a boy was kidnapped. He was killed. The prime accused led to discovery of the body, the weapon, everything. Now, there is nothing in the FIR. We do not know about the case diary against this person, but he is coming for anticipatory bail. His ground is that I am friend of that person who kidnapped. Therefore, people is searching. If that be so, we'll protect him. And if there are materials that he's a part of the conspiracy to demand ransom, then we will straight away at the motion stage itself dismiss it. That's why we wanted the case diary yesterday itself. It's a serious offense. A young boy going to school has been kidnapped, killed for ransom, and body was thrown out, and the prime accused led to all this. So if there are anything that he is also part of this demand of ransom, will not reject it. So that's why, is it possible at 2? Yes. If nothing is there, we'll even allow on the day 1. Let us see. Because we are apprehending. Why are you apprehending? Nothing is against you. Why are you coming to this court? So we want to see what are the materials against you.
Bail hearing BA item 27.
It's difficult to continue this bench for more than I'm now three weeks. Maximum case of atrocities and suicide. Forget about all this snatching of mobile and all. Okay, we can understand. From last 3 weeks, this is the case. The torture, demand of dowry, and suicide. From morning, I think we have dealt with at least 5 cases. Yes, case that what is?
Number the interest as per interest there is no external interest. No injuries from the body. This is a case of suicide.
Suicide seems it's suicide, but whether it will be for when marriage took place when? But you should know what not mentioned. See, within 2 years, unnatural death, torture is there. Presumption is against you. How many days? He was alive. Any state, any dying declaration. Investigations are also so bad. Yesterday we found a case on 4th of July. She took poison or something like that. She was hospitalized till 8/7, 4 days. Then she died in JNRC. There is no investigation. Even investigation officer has not visited the hospital. What is the brief history of the case? Why, under what circumstances deposited? Whether has she said anything before any nurse or anybody? Nothing. This is the way you investigate. And moment court will accuse, everywhere you will have that court acquitted. Why court accused? If no evidence is there, no evidence is collected, court is 57 days. To the satisfaction of
28.
Application number.
Mm.
Today's thing, correct? The lottery will see the anchor value at each 16. One.
Yes, who are you?
Now, my lord, this is the case of the property. Seriously,
Hanifur Rahman and another.
my lord. Now your lordship may turn to page 4, paragraph 4. My lord. I have narrated the case. My case. Page 4, paragraph 4.
This is AB or BA?
It's given.
What about the recovery from your vehicle?
Now, I'm starting. Now, recovery case is recovery.
Hmm.
That your lordship will find at case 15, my lord. The forwarding report, my lord. Count of arrest your lordship will see, my lord. Serial number 2, my lord.
Hmm.
37 numbers of ATM cards, 5 mobile phones, my lord,
Hmm.
and cash of rupees 8,110.
Then
Now, my lord, they were written in such a manner, my lord. Now, lordship may turn page 36 for a month.
yes,
Lordship has seen that, my lord. Now, 37 and 38, my lord. Is the injury report.
Hmm.
Now, my lord.
yes.
Now, your lordship may see the order dated 17/08/23 passed by this court.
But Mr. Das, kindly come to page 36. Yes. When a person is produced by the police, there must be a history that this happened, how this happened. Kindly see in both the cases, clinical history not provided. Suppose just now I told that suicide case. The moment a person comes to a hospital, there must be clinical history. What happened? How happened? She will say that I have taken this consumed poison because of torture, or she may say no, I did something. Those are the can be used as evidence. Here you see that there is no clinical history provided. Why? Now you see how they were produced before the police. We'll come to that. Okay. Now, yes, Mr. Yes, ma'am.
Found by this court on 7/08.
Page
I-
in okay, pass by this code.
Passed by this court.
Okay.
Document and directly to paragraph 4.
Yes.
So the learned counsel for the petitioner also placed reliance on the actual report and connects the bail application that the petition number 1 had suffered multiple displacement from error. Fourth figure associated soft tissue swelling of the petitioner number 2 and suffered fracture and swelling from it. Now the last part, my lord. The learned counsel for the petitioner had also produced the radiological report from the DMCs of the petitioner number 1, whereby the CT scan suggests posterior insert swelling from error that cannot be pronounced. Accordingly,
It should not be also. It should not be tried also, because our profession is something different. Yes.
but that original was kept in.
What we understand is brain operation is required. Reason is not necessary.
And accordingly, my lord, paragraph 7.
Yes.
Considering the CT scan report dated so which is detailed as a part of the record.
Interim bail granted.
The interim pay was cut. Now, my lord, the other person, my lord, Saidul, he had a fracture in his. To be honest, my lord, he is in the jail. So for the natural fall also, my lord, it's very difficult to can understand, my lord. Both hands are.
So you need
Yes,
assistance.
yes. My lord, that's why I create, my lord, I'm very technical in the party, in the college. For better treatment, at least one assistant or one nurse that to own of my own expense I can keep.
What is the case there? Offenses are serious. And it seems that the accident took place because head injury is there. Fracture may be subsequent whatsoever, but brain injury suggests that while chasing the vehicle, it met with an accident. Might be.
Fine. So therefore, my lord.
Otherwise, head injury would not
Yes.
have been there.
Therefore, my lord, there are 3 persons in the vehicle. The driver who was driving the vehicle and we 2 persons are behind. The driver was not injured. I have made a specifically statement in the bail application, but it's on both my lord, that I was hidden by the additional superintendent of police in the police station, my lord, by the what is my lord, the wooden part of the rifle, but wooden stop
Okay.
of the rifle.
Backside
Yes,
of the.
But I have made my lord. Let them reply to that. Let them
Okay, what is the case there? You file an
Yes, police
criminal writ petition or to police. We will confine to the one thing is that brain operation interim order is there. You can after operation you can have interrogation and all that materials are recovered. This is one part. Second part is what is he is submitting that a better treatment in medical college or an assistance from his family or anybody under security. That instruction you can have it. Now, what is the CD?
Sorry, but so petition number 1 is not correct. Father, my lord, he has asked 3 weeks for. Last time.
Now, what is in the case there?
You are proposed.
Yes, that's what are the method. There is a gang. They are a gang, 37.
Additional offender against them, 13 friends certain cases are registered in different police stations,
Hmm.
those are pending, and we will not very sure.
But what about this allegation?
I don't.
What about this allegation?
And it's one of the, because the FIR itself says, well, they were chasing, and when they closed the breach, he suddenly, you know,
That part will not go right now because this is a bail application. Now, if they come with a proper application, we may give in direction to independent inquiry or whatsoever. That is a different part. Now tell us about the second prayer. Suppose a person is, he may be accused, he may be a criminal, but if his both the hands are injured, admittedly, will it not be his right to have an assistance? Okay, we are continuing this interim order. We are not inclined to grant
Treatment has been provided to them.
to them.
My family is my lord, it is a day doctor, my lord. The day doctor is referred to BMC. Please come on.
So you are in where are you now?
The petition number 2 is in jail, my. My friend has submitted, my lord, 13 number of cases are there, my lord. And my friend to clarify to the court, my lord, whether in 13 number of cases, whether I was produced before the magistrate or not, after arresting. All are illegal detention.
You have not been even arrested
Yeah.
in other cases. So therefore not illegal. No detention is there.
even Ning says, my lord will kindly see the prosecutor case. All secret information they will say.
This is regarding the two. He needs a major operation for fixing this finger. No, do you have an instruction from the medical and health officer, district jail Moriga? We'll take it up at 2.
If I
Have your satisfaction.
No, this is not the way of finding a victim.
No, that's true, but ultimately a person is, this is 22/8. You have an instruction. No, this kindly go through this. If you dispute, that's why we want that you might have a instruction. Affidavit you can file it, but ultimately it's a question of Article 21. That's not an issue.
I will make it. Let a report be called from the state of.
You can,
Things are high. Things have to be taken more to proportionally.
no, that's correct. No doubt on that. But if in a case of emergent nature, suppose you see the last line. If that be the situation, suppose we delay it, assuming for a moment, the situation may so arise that you will have to ampute his fingers. So, I'm saying, so according to this court, these are situations, he may be criminal. We may not grant him bail at all. But so far relating to his this report, can we have an instruction through the learned additional PP at 2 that whether this has been issued? If this has been issued, we'll ask them that to do the needful for the proper treatment, nothing more than that. Proper treatment.
I'm not paying bail for him.
Not bail. I am not
Okay,
granting
fine.
bail. Not granting bail.
Yes, sir.
We want to see whether that much we want. You send on days of WhatsApp and Telegram. You try it. Delivering instruction that much. If that is said that no, this is not the actual situation, then we'll ask for a report. That much only, not more than that. We are not granting bail. Offenses are serious, and according to this code, the injuries shows that it was in fact an accident. There may be some torture subsequently, but accident was there. Otherwise, this kind of head injury would not have been there. This is the view of this court. We cannot we cannot enter into all those disputes, and I do not think this is a case for bail. That is also there, but I am concerned with the right of an accused, that much.
Yes, I have not paid also.
Yes. So at 2, we'll take up at 2 and we'll see that.
Item 29,
If that is-
Petition number 1, that 3 weeks.
No, we'll come back at, we'll,
I'm on that.
Looking for 39 days, application was 54 days in the Though case was registered under 489 A, B, and C, lordship, probably it's a case of 489 C, lordship. 100 rupees on the position that is bailable offence. 7 years punishment.
where is the affair?
After on page 19.
Who are you? You are Joydul.
Lordship, I am from Suban.
So
Suban Sami Khalil, lordship. Suban Khalil.
100 rupees a bundle of 100.
100 lordship, but lordship, this is in possession lordship. But the making and process, that is not mentioned in
We'll
that.
see, we'll see. We have to see the affair. You might have manufactured it.
But that has to be reflected in the lordship, FIR as well as the forwarding report.
No, that till that investigation is not over.
Manufacturing part is not there. The manufacturing part is there, lordship, and 489 A, B will come. lordship.
Now,
But
from
on the
where,
other-
what is your explanation? From where have you got this 100 rupees note?
Lordship, they are the stated lordship, they stated this is a recovered from their lordship. If it is recovered from the mere possession lordship, it will come under 489 C lordship.
We'll decide all this. Suppose I am saying that you manufactured in a house in Lotus Hill. Now, after interrogation, tomorrow you may lead to the manufacturing unit.
Lordship, that part will be reflected
In
in
the-
the forwarding report.
In the forward, on the day 1, investigation is complete.
Investigation, there must be some whisper lordship regarding process lordship. Processing lordship. there must
I am
be some-
learning the criminal law slowly.
Lordship, that part is not there, not even any instrument recovered from this petition.
Yes, what is this? City is not there.
Policy number, you know, morning time.
One.
Hello.
Had it been a 1 rupee somebody has given, you have taken a bundle of 100. Who knows that you are not manufacturing? Then why are you carrying this? We'll have
That
to
is the
see.
position, lord. That is the allegation. That is the position. lord.
Possession is admitted, recovery is admitted.
That's the position for 18
For a bail, that much is necessary to have the city.
in September.
8 September. So bail having, happy. No, 30 I will do, 30 column. Now 30.
items 3, 4, 6, 30, and 53.
All are bank employees. So all are BA. How many days?
Item number 3, from 18/8/20.
Tell us the date, don't say the date. Total. Item 3. लिखी जाए. Item 3, 40 days. All 40 days. 14. What is the stage of investigation and who are specifically implicated?
Investigation is going on. Anonymous case ready, madam. And from the university में kindly-
All are documentary.
University में kindly peruse page 29 regarding all in the forwarding report against all the accused persons. IO has specifically mentioned what are the allegations against the accused person. Actually, what happened, university में kindly come to page.
That Paul is the main. Dilip Paul is the main. Who is representing Dilip Paul?
Dilip Paul is not so this.
But others, I think they are not directly involved. Seems.
Because my problem is that all these banks are there.
What happened is,
Doing all.
all main accused is the Dilip Paul. They did it believing Dilip Paul, or maybe it's a banking system, we know. They are overburdened. So let these people go. We'll specifically state, make a mention of Dilip Paul. And when Dilip Paul comes, we'll think of it. What you say?
Yeah, I come for the Lord for network audit. Before was arrested, we had to after 9 years.
He already got default.
Default rate, okay. Then considering the period of detention, nature of material collected against the petitioner during the investigation. This court is of the view that one Dilip Paul is the prime accused in this case. Dilip Kumar Paul is the prime accused in this case. It is stated at the bar that Dilip Paul was arrested and he has already been released on default bail. Default bail. Full stop. Also consider the stage of investigation. The investigating officer has seized and collected material required documents, seized documents which are necessary in connection with this offense, and therefore considering the matter in entirety, the present application is allowed. To the satisfaction of CGM Kamrup Metro, 50,000 each.
So bail hearing, item number 31.
Now PP says voluminous CD. Now voluminous bail petition. Yes, where is the case? Where is the You are the informant. Page fire is at page 22. No, 18 is something GMDA. Circle Officer Dispute Verification of Authenticity of Land Document. Office of the Guwahati Metropolitan Development Authority. Page 18. Page 18 is GMDA. Page 15. Page 14, Annexure 2A. Just. Yes. 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 Where is, what is the address of this builder petitioner? Resident of? Okay. Yes. What happened
I
then?
am Sri Forest Injal, son of late Jiran Nikil Injal, resident of house number 2, Rambura, PS District, Guwahati Town, 5, informs
You are reading page 14.
page 18.
Yes. Hmm.
I am Sri Forest Injal, son of late Jiran Nikil Injal, resident of house number 2, Rambura, PS District, Guwahati 5, informs me under that I am one of the Patakaros land covered by Rajipur Square, Patakaros Square, village number 1 W2, Moja Delta Traffic, District in the district of Kamil Metro. Therefore, the basis of the complaint filed and undersigned is Kanu injured. So, Patakaros GMB issued a letter for top 2% and so forth to the Rajpur of method. K6 construction by data number 22 dated 37/2022. Copy of the same letter.
Okay, what happened thereafter?
Thereafter, my lord, this is after me, my lord, and that is why I had prayed and I was granted, my lord, prayer is great.
Yes, what is the criminal case?
There is a dispute regarding the plot of land and regarding the construction.
What is the cognizable offense made out in this case? Tell us that first. Tell us what is the cognizable offense? Yes. Mr. Rod, tell us. What is the cognizable offense that is made out in reading this FIR? To register an FIR. Fact may be different that there is somebody has violated building permission, somebody has taken land without no objection, constructed building, no problem on that. But tell us on this FIR, what are the cognizable offense made out?
First, my lordship may come to take.
Yes. Yes. Page 33.
There is no the position of that father that see, I mean, we purchase the slip that 63 for the day. If we 16th is we purchase the land, but he died on 6/3/2020. Next below line. Wife registration deed number 358480 measure came from 49 from the recorded Pataka Sri Mittal. Although as per state inspection, April 2005 found position of the ticket. It is known that the father of the king died on 6/3/2000.
No.
6/3 died by 63/2008.
Where is the allegation that this was manufactured by this man? You investigate all these are documented evidence, send it to forensic. This is not a case for arrest.
Then lordship may see one more matter. Lordship, objection. My objection.
Who are you?
I'm the man of the owner of the land.
You are owner of the land. Your case is that there is one of the pattadar. You got a kind of an injunction for no construction from the GMDA. File a civil suit, get everything declared and cancelled that this is a forced document. There is no allegation in the FIR of about any forgery of anything. Maybe previously says yes, show us the case diary. Where is the forgery? Who has done it?
statement from the cycle officer.
Hmm.
It is stated that there is a mutation was there,
Hmm.
but that was not recorded at that last time.
All these are civil dispute. Any findings that this person has manufactured any document? And what is his allegation? Allegation is that GFD has given no stop construction notice. He is we doubt that some workers are there. They may continue with the construction and therefore FIR registered. What is the cognizable offense made out? Interim order passed earlier made absolute.
32.
Yes. Yes, sir. Its statement is recorded of the
In this,
no earlier case, the statement of the
in this case, we received the CD, but the wrong CD.
okay, that will come back. The other case, the accused has recorded his statement before the IO.
I have to.
Okay, we'll pass an order that within 10 days record his statement. Huh? Okay. Yes, this case CD is
CD, we received the wrong CD.
okay. It is submitted by the learned.
22.
Any interim?
Interim is there.
Okay. The learned additional public prosecutor submits that by mistake a wrong case diary has been sent. Accordingly, he pressed for and is granted an adjournment. Please this matter.
Fourteen.
14th of September. Interim order passed earlier.
33.
Yes. Yes. PP, do you require his intervention? Not received the CD. You are enjoying interim. It is submitted that up to date case diary is not received. Accordingly, matter stands adjourned and be listed on 14th of September for production of up to date case diary. Interim order passed earlier.
34.
We are running a rehab center matter. One of the inmates died committing suicide.
We have granted bail to somebody yesterday.
We are all on interim. All are. Is there is missing,
We have granted the owner of the boy was it was an allegation of 302. No, that is different. That is different. Okay. Okay. But
we have a tendency, my lord,
this is a common thing. Now, what is the case there?
postmortem report is received.
Hmm.
Cause of death could not be ascertained. I mean, the person has been.
You have recorded his statement. Postmortem is done. All appeared, cooperated. Interim order made absolute. Yes, next.
35.
Yes. Where is the affair? You give a translated copy and ask us to see the vernacular. Why? For no confidence in the translation. Then, huh? Of course, it's a foreign language. Not received.
A number of occasions we send messages from my information that there has been captured part of the from April we are trying.
They should inform you that it has been transferred.
They have received the message.
the can you have a telephonic instruction? Then we can pass this. We can pass this order that though it was subsequently sustained.
We will not get the case number, etc.
Ah.
I'll take instruction.
Okay, on the prayer of the learned counsel for the additional public prosecutor, matter stands adjourned and be listed on Friday. Friday, you give us the instruction. Interim order passed earlier in respect of petition number 2 and 3 shall continue.
36.
Hmm? Where is the first affair? Search it file. You are in interim. It is submitted that the investigating officer, after completion of investigation, has submitted search sheet, submitted search sheet
Number 75 of 23.
being CS number
75 of 23.
dated
31/7.
in connection with so and so PS number. In view of the above, the present bail application stands closed, and the interim order passed earlier shall remain effective till the petition, till the trial. It is a sessions tribal. Sessions tribal. Offenses are session tribal. কি বলে? Shall remain effective till the matter is committed to the court of learned session judge and the petitioner appears before the learned trial court, learned trial court, and seeks for a regular bail by filing appropriate application. In the event of filing such application, shall be considered on its own merit. Definitely, when you are committed, when you are called, then only.
37.
Mr. Das, what we are thinking is, what is the meaning of filing a press application in if interim is granted, statements are recorded, search sheet is filed, will make the interim order absolute till the end of the trial. That is the law.
It is correct. Most guarantee is not on, etc. The police releases the.
But we'll develop an order which ensures that where interim order is there, statement is recorded, that the learned court grants the bail.
Around judgment is there.
We know, but there are some technical issues that there. We will develop a order. Which is what? 37, yes.
Court appeared granted on 9/6/2011. 9/6/2011, I have already appeared.
Yes, whatever.
Yes, sir, Tuesday receipt number 164 statement of the victim is also available. The result in the process medical report also for and the victim also gave another PM report of the statement of victim is also
Your blood sample is required. Will not give you bail. Arrest him.
I with the black man. I have already appeared with the police,
That you ensure. We are for the time being, we are not disposing it of full stop. We will come back and pass this order. We'll protect that investigation is properly done. We'll protect him and on his undertaking, he will take the samples for the DNA and send it for DNA matching. If that be done, no further interrogation is required, we will allow him. You will have to do that. Yes, we are coming back. Also, hard about learned education public prosecution. The case diary called for is produced. Full stop. The allegation made in the affair is that the accused, by taking advantage of the victim, had taking advantage of a situation of absence of other members of the family in her house, had sexual intercourse with her, for which she became pregnant. There was a negotiation for marriage. However, the accused refused to marry the victim and to accept the victim and to accept the child in the womb. Full stop. Accordingly, the affair was lost. The case diary produced further reveals that a baby was born. However, immediately after birth, the sweet baby expired. Full stop. The investigation further revealed that the IO has collected the bone of neonate baby and also the blood sample of the victim. Full stop. However, baby and sent it for to the forensic science laboratory. However, it is further revealed in the case diary that the blood sample of the accused could not be taken as he was found undressed. In view of the aforesaid material, the learned counsel for the accused, on instruction from his client, submits that he is ready and willing to appear before the IO for giving blood sample for the purpose of DNA sampling. In view of such submission, this court is of the in view of the submission, this court is of the view. Are you on interim?
Yes,
Yes. This court is of the view that let the case diary be sent back to the investigating officer and the petitioner be directed to appear before the IO within a period of 2 weeks from today for collection of the of his blood sample for DNA testing, as agreed and discussed here in above. Accordingly, it is provided that the petitioner shall appear before the IO within a period of 2 weeks from today, and on such appearance, IO shall do the needful for collection of blood sample of the petitioner for DNA matching by following due process. Till thereafter, the case diary be returned back. Till such accordingly fix this matter on after 3 weeks. 4th of October 2023. Till then, the interim protection granted earlier shall continue. If this is done, we will allow you to go. Yes, the case diary is returned.
38,
Yes, Gotthakor, any interim? What is the seriousness of allegation? What is the allegation?
Allegation regarding that fake currency note, that the informant said she have given 1 lakh of rupees and then she got 1,50,000, and thereafter again 7 lakhs were given. In return, she was supposed to get change. There is a illusion, and my younger brother is involved in this case. That is why my name is.
Is the mediator. And what about his brother?
Arrested.
Brother arrested. Okay. Okay. Considering the material available on record against the present petitioner, and also fact that the petitioner has cooperated with the investigating authority during the investigation on the basis of an interim order passed earlier, this court is of the view that no custodial interrogation is necessary. Accordingly, interim order passed earlier shall be made.
Much already.
39,
Yes. Third seated.
Annexure one thing that is there.
Just give me a minute. What is your name?
Two petition, Vijayanur Rahman, and another is
Shahjahan. Who is the petitioner here? Why have you joined us in the same petition? That shows everything. Shahjahan against Shahjahan allegation is something different.
Yes.
Mizanur is against, and both of you joined it. So meaning thereby you are comrades in arms, isn't it? Your responsibility was to save the girl, and you are guarding the gate. So you are that's the allegation. You have come together, isn't it? is the age of the victim? Huh? Where do you get that? The 160 statements. So what to do? You want bail? This is not a case. But the bailable warrant has been issued. Then where is the apprehension? Hmm. Why not? Milton? Sure. This is AB. This is an application under so and so, so and so. Filed by the two petitioners named Mizanur Rahman and Shahjahan Ali. This court, under its order dated, where was the call? Something was called for? When, which order? This court, under its order dated 28/7/2023, call for the scan copy of LCR of PRC case number 105/23 corresponding to Silapathar or it's Howli. Silapathar, yes, case number 538 of 2021 under section 120B/376 of IPC. Full stop. The same is received and perused. Perused the statement of the victim girl made under section 164 as well as the other materials available on record, including the medical report. Full stop. Considering the above, this court is of the view that the petitioner number 1, namely Mizanur Rahman, is not entitled for privilege of pre-arrest bail. Pre-arrest bail at this stage. Pre-arrest bail. However, considering the nature of allegation and statement made by the victim against the petitioner number 2, namely Shahjahan, this court is of the view that detaining him at this stage will be of no use, in as much as the role attributed to him is not serious in nature. Considering the above, the accused number 2, so and so is allowed to go on bail on furnishing of bail bond of rupees so and so with the following conditions. While parting with the record, it is made clear that this court, any observation made in this order may not be treated as a comment on the merit of the allegation against the petitioners. With the aforesaid, this anticipatory bail application. Okay. To the satisfaction of Judicial Magistrate First Class, Khemaji.
Item number 40.
Any interim? Okay, when? On the prayer of the learned council, learned additional public prosecutor, the matter stands adjourned till 15th of September 2022. The case diary along with the postmortem report be produced on that day.
Apply.
41.
Yes. It is received. Where is the affair? No interim. What is your name? Krishna Gopal Goswami. This affair is liable to be quashed right now. Do you know for what reason? You have no authority. Anyway, what is the CD say? How he is involved? Considering the nature of allegation and stage of investigation, will not comment anything, but this is an affair to be quashed right now. How? What is your authority to say foreign brittleness? You say that this is stolen. That is a different issue. It is the duty of the custom under Custom Act. You can inform custom. You will not only do the job of custom officials, but also of the tax officials, tax evasion. Inform it. Granted. So.
42.
This is the affair, Mr. Das. Details that seems like a custom officer seizing something. All are foreign brittleness. It has been booked as this from Agartala. It is foreign origin. Inform the proper authority.
In one of my cases, the says, handy covers to the custom official. The case which says handy cover to the custom officer, without informing the owner, it is responsible. And have made complaint and suspension to a fair and
I think there is a division bench judgment of our High Court, Ajal bench. Is that it? That you cannot. Division bench judgment. You cannot. Yes. Item number
42.
42 CD not received. Huh? All are lured. Yes, when? 19th of September. Allegation is serious. We'll have to see. This is not a case for. Yes, you can have a look. Hmm. Let the city produce the city. This is difficult because allegations are serious. What is the age of the girl? 23. We'll see the statement. For a time being, you whatever you are doing since May, you do that for how many days? 19. Till 19th, you whatever you are doing since to May, do that. Police will not arrest you.
43.
Yes.
Number one surrender and can
And how many petitioners?
5 petitioners, one surrender, but others are family.
Accused number one surrendered.
And alleged case dates are under schedule for being no engagement with that, not a single word about terrorism. In that fact.
Further the material. Petition number what the petition number one says and any other witnesses. Is it a case for bail? It can be granted. Yes. It is submitted that in the meantime, the prime accused, that is accused number one, has surrendered before the police and he has been arrested. So far relating to the other petitioners, they are family members of the accused number one husband. Who's the material so far collected against the present petitioners. Petitioners in the considered opinion of this court do not warrant custodial detention. So considering the above, the bail petition is allowed. Appear before the IO within 10 days, record statement and other conditions.
44.
Who to surrender your except petition who has already surrendered. Yes. Any suicide, not something?
The victim and the accused were about to get married.
Hmm? Hmm? What is the reason? Anything on CD? What is was he protected? What is his statement?
Also, from what you said, I don't know, he appeared.
Where is the mobile?
Actually, it is reflected in the affair.
No, not only affair, in the report also, that mobile is yet to be recovered. Where will the mobile go? Specific allegation is that you have taken away the mobile. It was in a place of occurrence. The information is said that you have taken away the mobile. This is the allegation in the affair. That's why they suspected. Otherwise, no suspect was there. The investigation says that mobile is yet to be recovered. Contradictions will not go to the contradictions right now. See, stories like this. You inform the father, isn't it?
Yes,
That I was calling her, she was not picking up the phone. So please do something. And you are worried because it indicates that there might be some fight between you and her. That's why you are worried. Otherwise, you are not picking up the phone. Not picking up the phone. You will call it later. You will go visit. She might have said that I'll commit suicide. So therefore, you urgently call his father, her father, and say, please go and see. To that extent, it is fine. So it's a case of suicide. But whether there is an abetment on your part, that is important. And second thing is that a specific statement was made that you also reached the place.
when I was informed.
You also reached the place.
Informed
You also reached the place because your marriage was fixed.
Yes.
Then her diary and phone was in her table. Phone you took away, that is the allegation. And investigation says phone is not yet been recovered, so they need your custody letter. This is phone is a vital evidence.
There was a crowd worship super heroes appeared before the IO, and the CS was already.
That's why you want to see his statement. Where is his statement? some cases we see investigations are properly done, Mr. Das. In some cases, we see investigations are done properly. But where it is required, it is not done. You had a video call at 8:27 from your phone. Show me his statement. What is your name? Statement is not recorded or what? Madam, did you get his statement? Huh? Okay, okay. Yes, madam, what to do? You're in interim. Allowed. Allowed.
45.
Hmm. Huh? So, who filed the first FIR? Who is that? City is there? Is it? You are Malika. How Malika is related to you? I am asking you, why should I go to para 12? What is the relation between Malika and you? No, no. Malika laws FIR against whom? Present petition. What is the name of the present petitioner? Selim Hussain. This is the FIR where you want a bail. Where is your FIR? So this was dated 27/7/2023. And where is your FIR? Case 12. It was on 26/7. What is your allegation? This was filed by whom? Your brothers. So Selim got injured.
Yes, and I was first admitted to hospital. Yes, 17. From 26 to 30. I was in hospital. I have to go to the it's 17. I was to see
Okay, so incident happened on 25. You were beaten on 26. They lost the affair. You were beaten on 26. Your brother lost the affair. And 27, they lost the affair. What they did is, instead of losing an affair, they took the action on their own. Isn't it? Not appears. That is the case. So therefore, you are also not entitled to bill. They are also not entitled to bill. Isn't it? Who are according to the victim, when she raised hue and cry, villagers came in. Any villager statement recorded? Any villager statement recorded? Her statement is fine. What villager statement? So, statement of villagers. Exactly the same story. We are beaten up for that. And it's not that she also informed her friends earlier that this man is giving me bad signals. Not a case for anticipatory. So attempt is not offense. Then rejected. We'll reject their case also. They are in still hospital. Okay. Rejected. Rejected. Yes, considering the statement of the victim and the other and the statement of the other witnesses, including the villagers. Rejected.
Again, 54 supplementary list.
Item
54.
supplementary. Yes, that's. Cooperative and material.
orders, item number 46.
We have rejected your bill. Granted.
For orders, item 46.
None appears for the petition around call. Please this matter after 2 weeks.
47.
Okay, this is repetition or what?
As well, my understanding is it presenting
In this case, repetition.
I have had to 47.
But this is repetition. No, no, other method. Okay. 47. What is 47?
47.
Okay. What was this?
In this money, we have challenged the entire ordered money. That is, I pay 5,000.
Okay. Okay. Why don't you compromise?
We are interested to compromise.
He is not. Okay. We'll give a try. Okay. You are Mr. N. Rahman. Learned Council has entered appearance on behalf of the sole respondent. Respondent number 2. Respondent number 2. Who is respondent number 1? State. Okay. In view of that, matter is ready as regards service. Accordingly, list this matter in the admission column. Not today, on the next day. Try to have something. We are not passing any order. List this matter in the admission column on Mosul.
13th of October.
13th of
Item 48.
April.
Okay.
Yes.
Newly engaged council in this matter.
Yes.
So we'll send a Nama today. So kindly read the matter of the
What was the subject matter? NIA. Maintenance. Theft of both the councils will otherwise will consider the interim period on the next day. You are Mr. S. Afridi Academy. The interim prayer made shall be considered on the next day fixed admission. On 13th.
Of Washment, item number 49.
Heard Mr. S. P. Roy, Learned Council for the petition. The present application is filed. I sought for some instruction. Any investigation is still pending because there is no stay, no case is made up. Kindly come to FIR. Where is the FIR? Page 116. Mr. Das, kindly come to page 16. This is a non-cognizable section 182. First and second, look at this FIR. But we passed an order because we any investigation completed, anything is done. We sought for an instruction. Nothing is. We said that except the FIR dated so nothing is available on record. The officer inside Sangsari Police Station, Kamrup Rural, is directed to submit status report regarding Sangsari PS case number 67 of 2013 under section 182 406. 406 should not come IPC along with all documents. If the case is still pending for investigation, submit the inquiry report if any why the charge FR has not been submitted. Finally, petition. He was there. It is otherwise a case of causing. That since FIR nowadays say that investigation should not be interfered lightly, all these are there. Otherwise, when immediately on 7th, 7th. I know that. It's a case of crossing. No, whatever, we need not go to all those things. The FIR, reading of the FIR do not make out any cognizable offense. Nothing. But problem is that this is pending since 2013. We do not know what is what. Just have the instruction because Friday we are not fixing. Thereafter, I think 3-4 days holidays. So on immediately on reopening, which Mr. Das Learned Council submits that he may be granted. I'll furnish a copy of this order to you. Mr. Das Learned Council for the Learned Additional Public Prosecutor submits that he may be granted time till 7th. 7th is reopening, 7-9, to obtain the necessary instruction in terms of the order dated 9th.
Let it be
11th of September 2023 to obtain instruction in terms of the order dated 1/6/2023. A copy of this, the Mr. Das is permitted to.
That order will be placed to you.
Okay, a
Copy.
copy of the order dated 1/6/2023 be furnished to Mr. Das, Learned Additional Public Prosecutor, for onward transmission to the officer in charge, Sanctuary Police Station. No case is made out. These cases should not.
For admission, item number 25.
Give a copy. You are Mr. D.K. Bordolo, Learned Council submits that he has entered appearance on behalf of the respondent number 2. Sole respondent. However, he further submits that he has not in receipt of copy of the petition. The Learned Council for the petitioner submits that the copy he will furnish a copy within a period of 2 days from today. Accordingly, this matter stands adjourned and be listed in the admission column. What is the issue?
The complaint on the ground of
Husband, wife. What was where is the cognizance taken? Complaint? 40.
And here.
Now helpless lady what will be your argument? Okay, we reserve the judgment on this point. We'll deliver it. 3-4 cases are there. But are those cases prior to Rupali or subsequent to Rupali? Rupali 498A said that when it is a lady taking a shelter any place, she can lodge an FIR. So whether the same principle can be applied in case of 406. Because you say that there is a specific bar in 406. Whether these judgments Rupali has been discussed. This is one aspect. Other aspect is that we have reserved a judgment on this point. So let it go a little bit in the month of October. In the meantime, we'll deliver the judgment. 9th of October. That was the issue. Same issue, similar issue, we already reserved it for judgment.
For hearing item number 50.
Should we start the hearing? At 2, I am having a division bench. 3:15 will rise. Huh? Some matters are fixed at 2, so therefore after rising from the division bench, I will come back. Then 3:15 will rise. Will it be possible to complete this hearing today?
It's all right.
Only have to get over, only.
So,
That is the logic.
uh,
First of September. It will take,
1st of September, many matters are fixed.
First types of.
See, otherwise we could have decided today. Today there is a reference. 3:15 will rise. I have a division bench with Honorable the Chief Justice. That may not take that much. We have fixed matters. How many matters are fixed at 2? 2 matters are fixed at 2. So even if we start, because we will have to decide on merit. Conviction is whatever is done, that is a different issue. But that we'll have to deliberate on merit, whether this case is made out or not, whatsoever, whether conviction is passed. So will it be possible within 45 minutes? No, not possible. So give a date, we'll fix it. Since he has gone, with only on academic.
But sorry, only fine part remains because 10 years, given consider for 10 years, 1 lakh rupees of fine. In default, 1 year further.
it's
So,
not possible on this part. Because
To give 1 lakh, so we'll decide at the earliest.
Otherwise,
if possible, can we have first of this,
First will not be possible. First, we have fixed all the matter relating to Jimma. And Mr. Kyle, all Ereka Natsar police are saying these are of origin, foreign origin.
that was 17.
Huh?
17 reopening the lawsuit, many matters fixed. Because of a
13th. 13th will find it decided.
My number always.
Yes,
Yeah,
13th.
they were also.
13th. 13th. Due to paucity of time, this matter could not be taken up. Please dismiss on 13th for hearing. We'll decide on that day. Even if necessary, we'll sit beyond 4:30.
Already, some part already working.
List is over. We'll come back at 2. Not 2, after rising from. Yes, sir. Yes, what is the affair? Is there a receipt? Oh, this case. This is the case, Mr. NJ Dotto argued. Any information, Mr.?
I have collected the phone number of the court.
Oh.
Report.
Oh.
Today, 13. Yesterday, they were on remand. The court below is on my. Serious matter. Although.
Case diary is here, na, Mr.
What client?
Huh?
What taking number to I going to sending to the market delivery.
Okay, okay. Third, Mr. Datta, learned.
Not submission. There is an IA member.
Hmm.
The IA is minor criminal 751.
Disposal.
Disposal. So there is an order by passed by this court on 25/08/23 by.
Hmm.
Documents in the second page, last paragraph by.
Hmm.
However, having heard the submission of damage advocates of both sides, I have carefully gone through the petition and document based on record, taking note of the facts and circumstances. It is provided that the superintendent is there, shall take necessary steps for sending the applicant to Guwahati Medical College Hospital, Guwahati for treatment.
So already you are in, that order is there.
They have not complied. That's not.
Okay. Considering the present health condition of the we'll do what we'll do is it's not a case of bail, maybe. It's not a case of bail. Considering that the petitioner number 1 is still hospitalized.
He is not interim and he is
Petitioner number 1 is an interim,
interim.
hospitalized, still hospitalized. The interim order passed earlier shall continue till the next date. It is revealed that accused number 2 needs, it reveals from the order dated 28/8/2023 passed by the learned magistrate. Magistrate Morigao, a copy of which is submitted by Mr. Doctor, reveals that the petitioner number 2 requires better treatment at Guwahati Medical College Hospital. Accordingly, though his custody was sought for, was rejected by the learned court below, only looking into the health condition of the petition. Full stop. It is also revealed from the order dated 25/8/2023 passed in IA criminal /751/2023 within bracket since disposed of, that a direction was issued by this court to the superintendent of district Z Morigao to take necessary steps for sending the applicant to the Guwahati Medical College and Hospital Guwahati for treatment with necessary escorts. Full stop. Mr. Doctor also submitted a certificate from the jail doctor, which also reveals that the petitioner number 2 requires better treatment at Guwahati Medical College. Accordingly, in the totality of the matter, and also taking note of the earlier order passed by this court in criminal IA criminal since disposed of, it is directed that the said order shall be complied with forthwith and a report be submitted on the next date fixed. Full stop. The final bail application shall be considered on the next date fixed. However, it is provided that if the petitioner number 2 is improved and can be interrogated, the same may be taken done with the intimation / permission of the learned magistrate, judicial magistrate Morigao. Okay. Okay, okay. That will be depend upon the advice of the doctor. Mr. Doctor submits that as the petitioner is as the both the hands of the petitioner are not necessary. If doctor requires that, they will give instead of we passing this order. Okay. Case diary be returned back. Let them be in the hospital. After hospital, we will give you the. Let the treatment be there. Okay. Give a date.
after his treatment, he should be produced to the medical board. Regarding his fitness and bring that to the job.
That we have said that after the treatment is over,
Regarding interrogation.
interrogation, you can.
What I submit after his treatment. What a medical board. He should be produced before the medical board to examine his fitness.
Okay.
I'm thinking of doctors. I will not see a problem
Okay.
with that.
Okay. For the aforesaid purpose, what is it below that him for interrogation, after the treatment is over, that will help you only. After that,
It is good for
both. After the treatment is over and treatment is over, the petitioners may be presented before a medical board, to state medical board, to report on the status of the health condition of the petitioner, so as to enable them, the investigating authority to do the necessary intervention. If so advised.
52,
Give a date a little bit later, unnecessary, this will,
50.
22nd of.
I think I am thinking of October, first week.
Then it will be 29th of September.
29th of September. Last, yes.
I am aware.
Yes, thus anything has come. Why he is apprehending? This case, that case.
Actually, he is called by, we have our IO says that he has been called as witness.
So we'll just protect him and go there. Okay. Considering the fact that petitioner is not named in the affair and he has been called by the investigating authority, it is provided that the petitioner shall appear before the IO within a period of 10 days. 10 days for recording his statement. And interim, first time, motion call for the case there and motion, interim, okay? You appear within 10 days. That's why I was a little bit apprehensive. Why he has come? Because otherwise offense is very serious. Inside my mind was that he might be involved in the demand of ransom. So if he is taking a stand that I am nowhere involved, police want him as a witness, let him be protected. Yes. No, I'm giving interim only. We'll record it. If we see in the case that he has an involvement, then we will reject this interim. You cooperate. Because it's a very serious offense. 15th of September. Interim we have given today. This is actually motion matter. So, anyway, I thought that it will take some time, but no, that hearing cannot be completed within an hour. And then I'll have to dictate it. I do not want to keep it as a CAV. I was thinking that I'll dictate it.